I'm a law professor here at the S.J. Quinney College of Law, and I'm here to moderate a really important and fantastic panel on the criminalization of trans lives and transgender care. We have three fabulous guests. We thought it might be two, but Dr. Dana Johns managed to figure out her call situation. So we'll begin with the first speaker. Professor Noah Ben Asher is professor of law at St. John's University School of Law. Noah attended Bar Ilan University School of Law in Israel and moved to the US, where they attended NYU School of Law for LLM studies, as well as a doctorate in law. Noah has done really important research on gender, sexuality, and legal theory. And they have a book coming out in 2024 called Secular Christian Social Justice. And Noah will be discussing their new paper, Transforming Legal Sex. Without further ado.
Hi, everyone. So thank you for having me here. It's such a pleasure to see old friends and to meet new colleagues and friends. It's really been a great time so far. Can everyone hear me okay? Yes. And this is our last panel of the day, so thank you for sticking around. And I know we will keep it interesting and exciting. All right, so we're talking today about criminalizing care and specifically trans lives in this particular panel. And as we all know, we're in a moment where there is a cultural, political, and legal assault launched by conservatives against trans people. It plays out in different ways that most of us are familiar with. And I'm just going to flag a few examples to start us off. How's the font? It's good. Okay, so denying access to gender-affirming locker rooms, restrooms, and public rooms. We're talking about stuff that started around 2020. And then excluding athletes from sports teams and schools, criminalizing gender-affirming medical care that we'll talk a lot about, and stuff like don't say gay policies. So there's just examples of the current moment, the current assault that we're seeing. And so in my scholarship, I often, I write as a legal feminist and queer theorist. And so I typically ask different kinds of questions. Here I'm asking in this particular talk, an article, two different kind of questions. One is more, how did we get here kind of question. So how did we get to 2023 where everyone knows what transgender is and we're all talking about transgender and we have positions and we know people or we don't know people, right? How did transgender become on top of or very high to the top of the cultural discussion? And the second kind of questions that I ask come more from kind of queer feminist and politics. And here the question is, how can we respond to this moment? So after we understand what is going on in the law and in the policy and politics, what is an appropriate response to this drama? So let me start with, am I moving? Yes. So how did we get here? Here I am I am humbled by the amazing research that has been going on by legal historians, not by some legal historians, but by historians of science in humanities departments, and who have been writing since around 2000. And these are just a sample of some of the books that I totally recommend, but there are many others who are really looking at a big picture about how the idea of biological sex has changed since the end of the 19th century. So these scholars are basically looking at kind of the medical discussions about what biological sex means and how it's changing in the end of the 19th century through the 20th century and to where we are today. Now, if I were to do the vulgar thing of trying to summarize all of this literature in like 2 sentences, it would go something like this, okay? And again, I'm sure the historians are going to hate me, but here it goes. Since late 19th century, medical experts could not agree on one clear definition of biological sex. So at first they start beginning, and they study this phenomenon by looking at what we call hermaphrodites, or people whose sex is ambivalent, right? We don't know what they are, either because they're born different or somehow they develop differently in adolescence. So medical experts are fascinated and they're studying the topic, and they decide that we need a sex binary. And so we're going to define it according to the gonads, right? So you can either you have female gonads or male gonads, and that's how we know what you are, right? That's the only definition, or the solid definition of biological sex. But then hormones are starting to get studied. So we understand that the hormones are also connected to this. So now we have the gonads and we have hormonal situations in which they also understand by studying animals, and this is around the turn of the 20th century, that the hormones matter as well, right? And then the genes, right? And then we have the XY and the XX discovery of those sex chromosomes. And now, after reading about 10 of these books, the conclusion is it's a mess, right? So then doctors don't know how to define biological sex. And they have what they now call intersex subjects, used to be hermaphrodites, but a lot of what we would today call transgender folks, right? Who have different identifications and are sometimes coming to clinics, starting from the 1930s, actually, at Johns Hopkins, and trying to get kind of understanding who they are and maybe get some help with hormones, maybe some surgical procedures, trying to understand the landscape that is clearly changing. So with the sex chromosomes, I just wanted to highlight that there's, we think of XXXY, but in reality, there are many more combinations, such as XXY and XO. And so even the chromosomal status is not really clear in many of the subjects. Okay, so bottom line, it's a mess, and medical definitions of sex are changing, right? At the same time, the legal authorities, and so I had tortured my RAs to find cases where legal sex had to be defined from the 19th century and on, right? Any case, look at family law, criminal law, wherever, right? And they came out with dire results up until the 1950s. Why? Because that wasn't really a question that legal authorities really dealt with directly. It doesn't mean they didn't deal with it. And so in my article, if you look it up, you could see that there are instances, but it wasn't a dramatic question until this guy, right? John Money. How many of you have heard of him? Fascinating character. You've definitely heard of him. Okay, very controversial character, but so he is, a short story is, he does his dissertation at Harvard. He is interested in hermaphrodites, right? And so he joins the clinic at Johns Hopkins in the 1950s, and he has this idea of social constructionism. He did not invent it. It was around for a long time, but he had this idea that actually our gender is socially, our mind is socially constructed, and our body is different from our mind, right? And he made that idea into a study research, right? He started studying people. Who did he study? Intersex children, and then transgender children later, right? Why? Because he wanted them to have a clear sex. He wanted them to be either male or female, right? So to just sum up kind of the importance of John Money, and people still write dissertations upon dissertations about him to this day. I know several people who are still writing dissertations about his different aspects of his personality and acts. But the important thing for law here, and here for the law folks in the room, is that he emphasizes and makes popular the idea that gender identity is an important component of sex that involves inner identification, right? That crystallizes in early childhood and is dependent on how the child is raised, right? So if you think about it in nature, nurture, he is saying nurture, right? It's about nurturing. And so when we read more and more about the idea, he wanted to have this additional aspect of sex to resolve the problem once and for all, right? Because now we have all these definitions of sex. So he comes up with the most important one, or the one that is going to prevail upon all of them, which is gender identity. He called it psychological sex and then gender identity. So he says, yes, we have all these ideas about sex. We have genes, we have hormones, we have gonads, but there's also that inner component. And that's, if we focus on that from early childhood, then we won't have to worry about the rest. Why? Because we have surgeons, right? The surgeons will fix it all, right? The surgeons will make it look okay, right? The parents will get the right gender in place in childhood, right? And then we'll have men and women, right? We'll have the binary again. So he was a big advocate for the binary. If you're wondering if homosexuality is a concern, of course it is, because the point of having a binary is to have heterosexuality, right? If you don't know if people are men or women, you don't know if they're gay or not, and that's a problem, clearly, right? And so he takes this idea of gender identity, right? Then transgender folks start showing up, right, in the 1950s. And we have, I'm sure many of you have heard of Christine Jorgensen. She's the first woman who had her gender affirming care. She did it in Denmark. She comes back and she's glamorous, right? And the nation is mesmerized, right? She's popular. She is a rock star, and she is the first transgender woman that people see, right, in the 50s. And suddenly sex can change, right? So the American consciousness around the 1950s is already rocked, because now we see that sex can change. She's a woman, right? And she becomes an advocate together with John Money and works for working there for gender affirming care for adults, right? So how is John Money's theory helpful here? Because in childhood we fix the gender identity. That's kind of the solid theory. But then in adulthood it's already done. So in order to help all those people that already have the gender identity that doesn't match their body, we have to help them, right? And in that sense, he was complicated, John Money, because he was a big advocate and ally for trans people, but a horrible advocate for intersex people, because he called for early surgeries on them to, quote unquote, fix their body. Okay. Brandon Teena, how do we get there? And so we have all these years between the 1960s and the 2000s, and I won't bore you with 40 pages of the article in which we look at different areas of law and see how courts across different areas of law, sex classification, family law disputes, anti-discrimination law, are getting with the program between 1960 and 2000, and kind of and looking for testimonies from people like John Money and experts about sex, who tell the courts, look, these people, they're transsexuals, they're suffering from gender identity disorder. The only way to help their misery is to help them change their bodies, and they have a gender identity that is opposite from what they were born as. And so in those years, we have kind of courts understanding, and legal authorities, other legal authorities, lawmakers, policymakers, understanding that gender identity is a thing, right? And that it has to be recognized in law somehow, right? Brandon Teena, how many of you have heard of Brandon Teena? Good. That's the Boys Don't Cry movie that you may have seen. So Brandon Teena is interesting for my understanding, first of all, of myself. So Brandon is in my generation already, and he's the first trans person I ever saw on film and in real life, in a documentary film. And eventually that's how I actually realized I wasn't even a lesbian, I was trans, right? What's interesting about the Brandon Teena moment, and here I want you to focus, is that this is 1993. Okay, so it's kind of the end of the era where courts already understand that there is this thing, gender identity, but he is in Nebraska, in a small town, and he has been raped by two people that have just found out that he was not a real man, right? And this is the conversation between Brandon and the sheriff. Why do you run around with girls instead of guys, being that you're a girl yourself? And Brandon says, and it's really hard to hear him. He's mumbling. He's really hurt. I have a sexual identity crisis. And the sheriff says, you what? Brandon says, I have a sexual identity crisis. You want to explain that? I don't know if I could even talk about it. So he's bruised. He's, his lips are bruised. He's really been seriously raped. And the sheriff lets them go, and they kill him shortly after. They just kill him and two other people. What caught me now in the last several years, looking at this discussion, and there's been a torts lawsuit against this guy, and he loses, this sheriff, is that Brandon says, I don't even know if I can talk about it. And this is already the end of the 20th century. right? So Brandon can talk about, he doesn't have the gender identity terminology yet, even though it's the end of he's in a small town, there's no internet yet. And so for him, he's like in the pre-trans moment. He doesn't know yet about gender identity. He's not understood by the press. Even the Village Voice in New York say this is a girl who thought she was, there's confusion in language still at the end of the 20th century. But something dramatic has happened since then. And so briefly, my article, kind of the nerdy part of it, looks at 3 different eras and shows how the legal authorities actually had 3 different phases, one in which they focus on the body early, and then kind of the harmony between body and mind along different areas of law. And what I call from the 2000s up until now is the gender identity era, in which gender identity becomes the leading definition of sex for many legal situations, right? And that leads us to the backlash, right? This is why there's a backlash. So my point is, sex has changed, legal authorities followed, and kind of culturally, politically, we now have a different definition of sex, and gender identity is an important thing. And we see it across different areas of law. And that has caused what we could call a moral panic, or we could call it a moral ideological debate over the soul of America. It is making a lot of people uncomfortable, and it has been politicized, right? And so in this context, it's important to see that when we look at the genealogy of how this happened, it is not a surprise at all that we have this moment right now, because it has been an earthquake, because we have changed the definition of sex, and now gender identity matters and is important in so many areas of law and culture. And it creates, again, this kind of uncertainty and anxiety for people who are less secure, or whose politics depend on a clear binary between men and women. So the kind of the last part of my talk in my article, and I know I have 3 minutes, right? 2 minutes, 3 minutes, is to say, okay, so sex has changed, legal sex has changed, and there's this like moral panic about it. But what do we do when we're responding? So what we have done, and by we I mean allies and trans people and allies and parents of trans children, is that we have turned to we have relied on medical experts for years, and we turn back to them for help, right? To tell basically legislatures that this is medically necessary, and to tell legislatures that these kids will, are at a mental health risk if they don't get help, and so on. We have also turned to human rights discourse, by which I mean we've turned to the constitutional claims, equality, liberty, and such. But what I'm noticing as a queer theorist is what we haven't done well enough, and I really want to do, both at the level of law, but also at the level of culture and engagement, is to insist that this is a moral question. And it's a moral question just as much as in Dobbs, and we've talked about it a lot today. Justice Alito said this is a profound moral question. Abortion is a moral question, and transgender is a moral question, by which I mean we are in the domain of changing sexual morality, right? We are in the domain of saying trans is good, or trans is not as bad, it's not bad, or cis is not, that we're in a moral discourse about what is good and what is bad. And we've done it with in Lawrence with same-sex sex, and we're doing it now with gender. And in abortion, it comes up as well. Is it a bad thing to have an abortion? Of course not. It's a matter of choice. It's a matter of freedom of choice. So my point is, when we make the arguments in courts, when we make them in briefs, and when we talk to people, we have to insist on the fact that it's not only a medical question, and it's not even only a question of liberal rights. It's a question of how we're shaping morality, how we're shaping sexual morality for the 21st century. And how we want to shape it. So even if we won't win the battles today in court, I believe that in the course of history, we are changing definitions, and we're just in a moment where we have to insist on the fact that this is a discourse that's not only about medical rights, it's about morality. So I'll end here.
Well, thank you, Noah. That was a really fantastic presentation. And now we're going to turn to John Mejia, who is the legal director at the ACLU of Utah. He graduated from the University of Chicago Law School in 2003. He later served as an attorney at the firm Sidley Austin, but had a bit of a hankering to return to public service. And in 2012, he moved to the ACLU of Utah, where he has pressed for criminal legal reform, protection of our democracy, and LGBTQ equality. And John will be discussing the flood of LGBTQ related legislation in state legislatures. So please, a round of applause.
Thank you. And just say, like, I didn't attend a lot of the morning, but like, I feel like I'm a practitioner. So like, this is like a report from like the trenches, right? So, as Noah was mentioning, there has been a flood of attacks against the rights of LGBTQ plus people in the United States. Just in 2023 alone, the ACLU and our affiliates tracked 505 bills in 47 state legislatures that targeted the rights of LGBTQ plus people in various areas, including healthcare, public accommodations, and schools and education. And a large volume of those bills were specifically targeted at trans people. And, it adds to an already distressingly high number of state statutes that, single out these people. And in 2023 in Utah, we had 9 such bills. And I'll just say that in, the ACLU of Utah, the way we work is not just by suing, which is my department and my often favorite part, but I'm beginning to sort of much more appreciate and understand sort of the work of community organizing and, have long understood the work of lobbyists. So, if you look at this, distressingly long list of bills that were targeting, anti-LGBT bills in Utah from last year, you'll see that a lot of them did not pass. And, that a lot of that was because of, very hard work by, community and lobbyists and interested people. Unfortunately, and a lot of them that didn't pass, passed in sort of like the Utah nice version, right? So, House Bill 132 didn't pass, but SB 16 passed, for example. So I think, I'm going to talk today a little bit more about bans on transition-related care for trans youth in the country. In 2023, 18 bans on gender-affirming healthcare for minors were passed. And that brought the total of such bans to 21 states. And those have passed just over the last 3 years. And so we estimate that that's about a third of the country. So we think that there's about 100,000 trans kids between 13 and 17 who now live in states that have banned their healthcare. And, as I mentioned, Utah is one of those states that enacted such a ban, and that's SB 16. So that law was called Transgender Medical Treatment and Procedures Amendments. And it is a ban on transition-related healthcare for minors in Utah. It went into effect immediately, January 28th, 2023. And something about that date, the legislature starts in early or right around that time. So January 2023. So this was the result of maybe a week or two at most of legislative process, which is not legislative process. And it's sort of an echo of what happened the prior session around the bill, a bill that outlawed trans girls playing on high school sports teams for girls, where, the legislature had worked all session on that. And then sort of in the dead of night, on the last day of the legislative session, passed a complete ban. In 2023, I guess the legislature decided that we're not going to even mess around with really listening to people anymore. We're going to pass these very controversial bills within the first week or two of the session. And that's what they did here with 2/3 of the vote. And so, it's a degradation of from my opinion, from my point of view. It's not the way that legislative process should work. There are a lot of very, well-informed stakeholders that could have had a say in this legislation, and instead, this is what happened. So I'm going to go through a little bit of about what the law says. It is a summary, not intended as legal advice. So the ban went into effect on January 28th, 2023, as the session continued. So if you are a transgender minor and you have not been diagnosed with gender dysphoria before January 28th, 2023, you are not allowed to receive any sort of transition-related or gender-affirming medical care. And it does, the bill does not ban mental health providers from diagnosing gender dysphoria or providing supportive therapy to youth, including supporting youth who socially transition. So it's focused on puberty blockers and surgery. But starting on January 1st, 2024, if you're a covered healthcare provider or professional, there's going to be new requirements and a new certificate and new training required if you're going to diagnose or treat transgender minors for gender dysphoria. And we are watching very closely the trainings and guidelines that the Department of Health and Human Services in Utah is going to promulgate for that. So SB 16 didn't ban completely healthcare for transgender minors diagnosed before January 28th, 2023, but it does impose barriers. So the bill says that if you were diagnosed before January 28th, 2023, and you've been being treated for gender dysphoria for 6 months, that provider can provide care for you. Again, the same requirements for certification and training will apply to these providers starting on January 20th or January 1st, 2024. And yeah, we're looking very carefully about what that's going to look like. And speaking about sort of the way that this plays out in Utah often, that ban on transgender kids playing sports, girls playing sports, we got that put on hold, but that when put into effect a commission. And now if you're a transgender girl who wants to play in Utah, play high school sports in Utah, you have to go before a commission. Well, that commission it was supposed to be made up of experts, and it's made up of sort of very politically motivated people that are not experts. So again, we're keeping a very close eye on what Utah does in promulgating these rules. And then SB 16 bans surgical procedures for all minors in Utah, regardless of when they were diagnosed with gender dysphoria. And then another thing that SB 16 did was to place a lot of risk on practitioners in Utah for malpractice related to their treatment of transgender minors. So SB 16 allows someone who gave informed consent relating to treatment when they were a minor to withdraw that consent and disavow that consent up until the age of 25. And then if they withdraw the consent, they can then go back and sue their provider for medical malpractice. So, despite the rapidity with which the legislature passed SB 16, we urged the governor to veto it. And we pointed out that, Governor Cox had vetoed the sports ban and called for, compassion and urged, caring for people. That was not persuasive to Governor Cox this time. So at the ACLU, we do not believe that this kind of ban passes constitutional muster. And there are, for the non-lawyers in the room, in our federal system, there are two constitutions that at least two constitutions that apply to the people in the states. So you have the federal constitution, which everybody knows about, the US Constitution. But then every state also has a state constitution. And I like to say that like the federal constitutions in general set floors, right? And not ceilings. So the federal constitution will protect a right up to a certain point, but then the state can protect that right much more, right? So, the federal constitution could say that, one course of action for a police officer is not reasonable under the federal constitution, but then the state could add additional limits on police power. So just given the climate of what's going on with the US Supreme Court, a lot of what we're doing at the ACLU and a lot of what rights activists are doing is looking to potential state constitutional claims to where, for example, I'll give a very recent, timely example. After Dobbs, there is no federal constitution for abortion care in the United States. But at the ACLU, we, right after Dobbs came out, we made a claim that, well, abortion care might be covered by, or is, not might be, abortion care is covered by the Utah Constitution. And a Utah state court agreed with us that we had raised serious questions and enjoined the law. So the reason why abortion care is legal in Utah today is because of the Utah state constitution and the Utah state courts. So that's why I'm beginning the analysis of what the potential problems with SB 16 are, or the problems with SB 16 are with the Utah state constitution. And specifically, I think there's a very strong potential claim against barring transgender care for minors in Utah, in the Utah Constitution's Equal Protection of Laws Clause, which says that all laws of a general nature shall have a uniform operation. Sounds kind of boring. It's kind of like the Equal Protection Clause analog of the Utah Constitution. And in general, courts have read that to mean that if you are challenging a law that makes categorizations based on sex, then the court will subject that law to heightened scrutiny. So, in general, if a law is just not attacking anybody in particular, it's just sort of a general law, you generally have to have like a rational basis to do it. And then on the top, if a law is sort of talking about trying to make a distinction based on race, that is highly scrutinized. That's almost dead on arrival. But laws based on sex are subject to something called intermediate scrutiny. And that's like a federal model that the states have adopted. So in the case I was talking about on the sports ban, it's called Roe versus Utah High School Sports Association. The Utah District Court looked at the Utah Constitution and said that singling out trans kids for different treatment is a potential violation of the uniform operations of the law clause because it is based on sex. So under the federal constitution, there's also some problems. So same potential claim under the Equal Protection Clause that this is sex-based discrimination. And then we've seen challenges to this kind of law in other states. In federal court, make claims about due process. And the Due Process Clause protects sort of named and unnamed rights. And one of the unnamed rights of the Due Process Clause is you get to, as a parent, you get to determine what is the best care for your child. So, unfortunately, Utah's not the only state that has banned this kind of care. It's happened across in those 21 states that I talked about. And a lot of lawsuits have been brought in federal court. And in each of the district court, so there's 3 levels in the federal court. There's district courts, and then there's appellate circuit courts, and then there's the Supreme Court. And at the sort of trial court level, the level where the judges are hearing the evidence and hearing from the parties and hearing directly from people, every federal district court that has heard this kind of challenge has found that there's a likelihood that these kinds of laws violate the Constitution. So, for example, in the 8th Circuit, the district court in Arkansas issued a preliminary injunction barring in Arkansas from enforcing a law that prohibits transgender care for minors. The Eighth Circuit, so that second level, actually affirmed that preliminary injunction, saying that the Equal Protection Clause applied. And then after that happened, the district court held a 2-week trial, and there were experts and parties that testified it over 2 weeks. And after hearing all of the evidence, the court ruled in the plaintiff's favor and permanently enjoined that law from going into effect. So first they said that the ban improperly discriminated against transgender youth based on their sex. They found that the court found that the ban interfered with the parents' ability to make medical decisions for their kids. And then in this ban, doctors couldn't even tell patients about transition-related care if they were minors. So the court struck that down under the First Amendment. And so the state appealed that permanent injunction to the Eighth Circuit, who has taken a very unusual step of hearing that as a full court. The Indiana court, federal district court, had a similar ruling, but it's preliminary. And then unfortunately, in the Sixth Circuit and the 11th Circuit, the appellate courts have overruled what the district courts did. So in August and September, sorry, I confused myself with the language. But the point is that there were preliminary injunctions in Tennessee and Kentucky, and those were struck down by the Sixth Circuit, who said that the plaintiffs' claims of equal protection and due process were not valid. And there had been also a preliminary injunction in Florida, and the 11th Circuit struck down that preliminary injunction. So in Tennessee, Kentucky, and Florida, there is currently an in effect ban on gender affirming care for transgender youth. So this kind of this news is actually big news, because this Supreme Court, it's very scary to be before the Supreme Court. So we, thinking through all of the options, the ACLU is counsel for some of the plaintiffs who in the cases in the Sixth Circuit, and we last week filed a petition for certiorari to the U.S. Supreme Court, which means that we are asking the Supreme Court to rule on the constitutionality, or to rule on our claims and to overrule the Sixth Circuit. And then I have a video of our clients, and just because I was thinking, how should I end to talk about the importance of this kind of care and what's at stake in this fight. I don't think I would say it as well as my clients. So I'll just end by playing the video.
After I received gender-affirming healthcare, I felt a lot better about myself. I had the vial sitting up on my shelf, and I'd always look at it. Always. It's like finally getting what I wanted for like 7 years.
It just gave me hope, and it gave me the confidence that I've never had before. I got to the point where I could look at myself in the mirror and like what I saw.
If there was one thing that I could do, it would have been started sooner. Sure.
When I first heard about the legislation, it was like a punch to the stomach. It was like I couldn't breathe.
We're left with this terrible, awful feeling that we're not able to make medical decisions for our child, and that's scary.
This healthcare that they're trying to ban is essential to not only my well-being, but quite literally my life.
It just drives the point home that we have to do this for these young people. We have to do it.
We joined the lawsuit with the ACLU because Brooke deserves access to health care.
We also knew that not everyone could put themselves out there in that way, but I felt like we could.
And we're going to do whatever we need to do to make sure Sabrina is happy, healthy, and thriving. And that is what self-care has done for her.
I hope my community can accept me just the way I am.
So that was called gender affirming care is life-saving care. And I think that's what is at stake. And that's why we will continue to fight. And that's why we
One simple but brilliant trick to heat your...
And that's why we encourage everybody to join the fight and continue the fight. Contact your state legislator, tell them that these efforts to attack transgender youth are despicable, and that you oppose this kind of law. Do whatever you can. Thank you.
Thank you, John. That was a really great presentation and super meaningful. So next we'll turn to Dr. Dana Johns, who is a board certified plastic surgeon here at the U. Originally from Pennsylvania, she obtained her medical degree from Thomas Jefferson University Medical College and completed her residency in plastic and reconstructive surgery here at the U. She has written numerous articles on gender-affirming care and care of transgender patients, and she will discuss the provider and patient perspective on these trans healthcare laws. So without further ado.
All right. Well, thank you for having me. I feel like my panelists so far have led really nicely into my presentation, which basically is going to show you what these laws look like in actuality. So I'm going to go through a little bit of provider and patient perspective for criminalization of trans healthcare. I have no disclosures. So I think the hardest part being a physician when laws are passed that affect the way that you can provide patient care is that you've dedicated your life to being an expert in a field where you have, where you feel like what the decisions you're making are based on the guidelines of all the other experts in your field. This is a list of medical organizations that recognize medical necessity of treating gender dysphoria and endorse it. I'm not going to read through this, but you can see that there's quite a few. So these are all of the people who have dedicated their lives to trying to do what's best for patients across the board and coming up with protocols that, are evidence-based and that say these are the types of standards of care we should be providing patients. So many of you probably know the World Professional Association for Transgender Health, which is WPATH. So they came out with their recent standards of care guidelines. And these are guidelines that talk about every aspect of treating transgender and gender diverse humans. And they are, worked on by people across the globe. This isn't just one country, one group of people. This is input from everyone who is doing this sort of care, and it's evidence-based and outcomes-based. In WPATH, the Standard 8 guidelines, there are 25 pages on adolescent gender-affirming standard of care, an additional 13 pages on children who you don't yet consider adolescents, gender-affirming standard of care. And this is well thought out, well documented, research-supported standards of care. I don't expect you to be able to read this slide, but it's to the point that these are the statements of recommendation about adolescent standards of care for transgender and gender diverse humans. And in all these little points, it talks about things from a multitude of standpoints. So what the providers should be able to do, how they should be trained, how they should approach care for gender diverse individuals, recommendations on, what sort of multidisciplinary care and what the overall care paradigm should look like. And then, of course, additional recommendations for care for medical treatment, surgical treatment. It goes into everything. The American Academy of Pediatrics also has a pretty extensive policy on treatment and standards of care for gender diverse youth. And in August of 2023, the AAP reaffirmed the care policy that was originally placed in 2018, and then wanted to also authorize a systematic review of additional evidence to guide future updates. And I just kind of wanted to point out some of the more kind of important parts of the care paradigm, because this is the front line for our transgender youth. These are their pediatricians, their primary care physicians. These are often the first people who are going to be interacting with this group of individuals, and they're really important and kind of can start off the care for these kids in a way that's really going to be life-changing and improving. So they have a gender-affirming care model, which I thought had some really great points. And so the first thing is that, transgender identity and diverse gender expression is not a mental disorder. Gender dysphoria is a diagnosis in our DSM-5, from a psychology standpoint. However, it's not constituting a mental disorder. Variation in gender identity expression are normal aspects of human diversity, and there isn't a binary. Gender identity evolves over the course of time, over the course of a child's life. And this is an interplay between biology, development, socialization, culture. There's a lot of things that go into this. And this is part of what these pediatricians are trying to help the child to figure out and to travel through with them. And then I think that this last one is really important because I think that in the public eye, the reverse of this is being stated. So this is that if a mental health issue exists, it most often stems from the stigma and negative experiences that the child is undergoing rather than being intrinsic to that child itself, which means that the gender expression is not a product of a pre-existing mental disorder. The mental health issues are stemming from the gender diverse expression. And the gender affirming care model is best facilitated through the integration of medical, mental health, social services. And this includes resources for both the patient, the child, and the parents and the family. So it's not just isolating in a bubble. This is really a whole family type of care. They talked about developmental considerations. And one of the things I thought was interesting was that currently they're saying that more robust and current research suggests that rather than focusing on who the child will be, valuing them for who they are in that moment, even when they're really young, is most important for fostering secure attachments and resilience. And that's not just for the child, but that's for the whole family. And that's going to transcend into every other aspect of their life and their ability to form relationships and navigate the world. And so, supporting what that child's identity or process is in that moment is really what we need to be doing. And then they go on to talk about medical management and what we're going to do from a medical standpoint. And it really, the overall arching theme of this is that it's a multidisciplinary approach. There's multiple facets to this care, and we want to make sure that the child is able to get all of that. And in addition to this, it's not just the child, it's the family. So we're including everyone in this care. And then I think also most importantly that there's no prescribed path, sequence, or endpoint. So we're not trying to take a child from A to B. We're letting that child take its path and end up where it ends up. And we're there to guide it along that journey. Why does this matter? As I think was mentioned before, transgender youth, so the CDC just did a study then showed that 1.8% of high school students identify as transgender or gender diverse. And 1/3 of these humans have attempted suicide. This is multitudes higher than their cis peers. And, the reality is that we're doing this because of this, because these kids are at risk for not being here. I'm not going to get into this too much because this was just talked about, but, so this came across as a, provider who provides this type of care. And I don't read law on a regular basis, and it is hard to read as a medical human. And what I found is that there were some things that just seemed very hazy. And to me, as a provider said, I don't actually know what I'm legally allowed to do and not do. And this was one of the, I kind of what they characterize as secondary sex characteristics, surgical procedures. And one of these in a assigned female at birth is a breast reduction surgery. And a breast reduction surgery in general, in a cis female, is done for relief of symptoms. So they've got very large breasts, they're heavy, their neck hurts, their back hurts, they can't exercise, they're uncomfortable in their body. We're allowed to do this on minors, cis female minors. Can I do this on a gender diverse human for relief of symptomatic macromastia without getting in trouble by the law? Unclear. So this is where we live as providers. What can we actually do? I'm not going to read the slide either. This just shows you that for the people providing primary healthcare to these minor humans, these are the requirements. There's like 1 million of them to provide puberty blockers and hormones. These same medicines are being provided to cis youth. These are not the requirements that you have to undergo if you are providing these medications to cis youth. And then this was already sort of mentioned. This is the place where we're like, we don't actually know what sort of, malpractice claims are going to be brought up against us. It's a very uncomfortable place to sit as a physician to not know if the care you're providing is going to subsequently be criminalized. So the American Society of Plastic Surgeons also has a statement on this. And they've basically, this is across the country. They said there's a common thread that there's been prohibition of gender affirmation care for minors, that they're basically taking away certain procedures and medicines. And in addition, that there's, it's making a stipulation that it's illegal for minors' parents or guardians to consent for procedures. And the penalties are varied, big fines, child protective services, and felonies. I mean, this is like a wide range of things. And the ASPS has basically said, we believe that our services can help gender dysphoria patients by aligning their body with who they know themselves to be, and that we're going to continue to fight the laws that are coming up that state otherwise. So these are the arguments that we kind of have been thrown out, against gender affirming care for minors. There's not enough research. It's experimental therapy. Cox said it himself. False. So if you just put into PubMed gender affirming care, and you could put in a bunch of different other things, you get over 2,000 hits, mostly since about 2015, on research done on gender affirming care. So this is not like this magic new field that popped out of nowhere and we have no, results on it. There's additional research in this, in addition to a lot of the things that we do in other facets. Puberty blockers have been approved since 1993, FDA approved, which is kind of hard to do as a medication because there's like one thing each medication is approved for and everything else is off label. So 30 years later, they still remain the gold standard for treatment of precocious puberty in cisgendered youth. So you can give this to a 6, 7, 8-year-old who's going through puberty to halt it. We know what the outcomes of that look like because we've been studying it for 30 years. This isn't a new drug. And everyone's being monitored by care teams. We're not just putting patients on medication and peace out, good luck. They're being taken care of. The UK has stopped prescribing puberty blockers and hormone therapy to minors, so we should too. Also false. The NHS has has tried to make it so that they can have more control over medications being given in a setting. So they've opened 4 new clinics, and through those clinics, gender diverse minors can still receive, new ones coming in, can still receive gender affirming care and puberty blockers, but they have to go through the proper avenue, meaning that they don't want a bunch of random people who maybe aren't well, trained prescribing these kids puberty blockers, which is fair. And this leads me to my favorite one. Kids are ill-equipped to decide on gender-related medical interventions. Their brains aren't fully developed, and parents shouldn't have the ability or the right to permanently alter their child's body. We do cosmetic surgery on minors all the time. In the ASPS documentation, the responsibility falls on the parent to help their children make the right decision when it comes to cosmetic surgeries. This is 64,000 surgeries in 2015 between the ages of 13 and 19 that were performed on children. The only thing that we require is parental consent. We recommend that the teen initiates the request if they have realistic goals and sufficient maturity, but it's not required. We do cosmetic rhinoplasties for psychosocial reasons to help minors feel better about their body, alleviate psychosocial distress, and allow them to, feel like they're living their best lives. We allow parents to consent to do cosmetic surgeries on 5-year-olds, to set back their ears for no purpose other than they think that it's what's best for their child to not be bullied, to not have to undergo psychosocial distress through elementary age years. This 5-year-old's brain is certainly not developed. They do not understand the ramifications of the surgical interventions that we are performing. But their parents are allowed to make that decision for them because they have parental rights for cis children. Gynecomastia. Cis male excess breast tissue growth at the time of puberty, usually. Their body doesn't align with their gender identity. They have a body that represents something that they are not. It causes them psychosocial distress. They get bullied. They feel uncomfortable. They don't exercise. Other health problems can happen. I'm allowed to do the surgery on cis males with breast tissue. It can be pretty bad. You can have a significant amount of breast tissue as a cis male. And I'm going to do a surgery with double scars and free nipple grafts, which looks shockingly like this illegal surgery that I'm not allowed to do anymore, for the same purpose of aligning the body with the gender identity. So what does it look like when government dictates healthcare? It criminalizes standard medicals of care that have been recommended by societies who have experts who this is what they do. It interferes with my relationship with my patients, with my family. I can't provide the healthcare that I want to be able to provide, and these families can't receive that healthcare that they need. And it vetoes the ability to have shared healthcare decisions. We can't, parents can't help make the decision for what they feel like is right for their child. It's doing two things. It's taking providers and making it so we're unsure if we can, what care we can perform. And some are just like, I'm just going to stay clear and not even perform any care, even in states where some of it remains legal. And that then makes it so that these families, these kids, have to decide between their state and their healthcare. Do they drive 5, 6, 7, 8 hours to another state to get healthcare? If they can, it's going to take a group of individuals who, as a whole, are already marginalized, already at risk. And then within that group, it's going to segregate them even more, because you're going to have the people who can do that. You're going to have the families who can take their kids 8 hours to another state. And then you're going to have the family that can't, because they can't pay out of pocket and they can't take off work and they can't make it there. So you're going to take that group that's already marginalized and marginalize it even more for the people who don't have the means. And this is where we're talking about, the level of discrimination here, and the results are pretty outstanding. And I think that the New England Journal of Medicine summed it up best in this article on criminalization of gender affirming care. They said, "We believe these bills threaten health, well-being, and survival of transgender children and young adults. By penalizing physicians for practicing evidence-based medicine, the legislation nullifies their expertise, interferes with the therapeutic relationships among physicians, patients, and families. It strips power from patients and families who are already marginalized. And although the stated purpose of the legislation is to protect adolescents, we believe that criminalizing what has been shown to be life-saving treatment will do the opposite, and the consequences could be tragic." Thank you.
Thank you, Dr. Johns. That was really, really interesting and important. And so as moderator, I am going to seize my moderator's privilege and ask a question, which a couple of you touched on. Now, I work a lot in consumer protection and health law as well, including in cancer. And our society really under-regulates the carcinogens in our everyday products, including air and drinking water. And I don't really see that much fury over that. I mean, there is some, but I see a much larger backlash against transgender care. And that's very surprising to me. And some of the rhetoric is in consumer protection. And so I want to ask y'all, is that a pretext to discriminate? And what is the role of pretext here? If you think that there is pretext going on, whether it's consumer protection or other goals such as protecting detransitioners or what have you, what is the role of pretext? And how can that be leveraged, if it can, both as a political matter and in the law? Now, there are some legal cases where pretext became really important for the decision. So there are multiple facets to this question, but I'd love to hear what y'all think.
It's like the law person talk.
Okay, sure. I mean, yeah, I mean, and from my perspective, it's pretty clearly pretext. And when you're looking at the effects of a law that discriminates based on protected classes, the reasons for doing so, I mean, it can, like, the importance of the reasons sort of can depend. But when you have sort of a clear animus against a group, that's a pretty slam dunk way of challenging a law. So
Right. And I would agree and just say it's not only pretext, it's pretext. It's not pretext for discrimination. I think they just don't want trans people to exist. It's not that they want to discriminate again, they want to eliminate us. And I think the way to do it is to avoid the trans children, right? It's not just discrimination.
Because I mean, basically what they're stating is that this group of the trans people can't exist for this to be real. Like if I can do the exact same things on cis children that they're banning me on doing on trans children, they're just saying that they don't believe in transgender, period, the end.
Right. I agree.
Yeah.
Well, just as a follow-up, I mean, if you look at the history of discrimination, often there is an interest in subordination, in having that extra status. But it sounds like what you're saying here is that the interest is a little bit different. Is that right?
Yes. I think the panic is so big now that, I mean, if you look at it from the 80s and on, it's, okay, we have to accept gay people. They're here, they're getting the right to marry, we'll tolerate them, it's okay. But this thing, I think it's just one step too far, and they just really don't want trans to exist. So it's not oppression, it's elimination. I think that's the kind of what is happening. And that's why we need everyone working together to call them out on it and do something.
Yeah.
Okay. So from the audience, and please continue to add questions to the queue, and I'll be sifting through these. So litigation seeking to strengthen parental rights to make medical decisions for their children may harm trans youth whose parents deny care. What legal strategies exist for trans kids whose parents deny them health care?
yeah, I mean, I do think that parental rights can be a two-edged sword. The one thing that comes to mind is and I'm not saying that this is possible in the medical treatment field, but for abortion care, there is the right of a minor to petition a court to overrule a parental consent law, to have a court declare that they are sufficiently mature, or that it's in their best interest to have the abortion care regardless of their parental or guardian's consent. So that's just off the top of my head that, parental rights, they're not absolute either, right? No right is absolute. And kids, despite being largely subjected to their parents' oversight, they also have their own rights as well. So I've not really thought out how that would play out if there was a difference between what the parents thought and what the child thought. But I think we do recognize that could be a problem.
Yeah, and just to add to that, and what happens in reality is that these conflicts do come up when parents don't agree with each other sometimes. So you have a parent who agrees, a parent who is a little bit less behind, and then it can play out in a divorce conflict or before or after the divorce around custody and stuff like that. So it'll involve other things.
And so when a parent does sue to protect their child's right to get transgender care, does that actually, by increasing parental rights, then undermine the rights of the other kids?
Of the other parent?
Oh, no, of the kids who have parents who don't want their kids to get transgender care, if that makes sense, because it's strengthening parental rights.
So you're saying there's like a different class here. There's the class of kids, of trans kids who don't have parents who support them versus the class of kids who do have parents who support them.
Right.
Yes.
Right.
And that's going to often map on other kind of discriminatory issues, like the parents who can travel and the parents who can't travel, and and how educated they are in it.
I mean, when kids who come through and clinically, and you can see there's a group of kids who come through whose parents are very supportive. They're there from they're listening to their child. The child's been undergoing gender care for numerous years. And then you have the ones I've had, patients who come in with their parents, and it's like the parents are there, so kudos, but they're still, you feel the pull, and it's a little bit of give and take. And then I have the patients who come when they're 18 because they said this was not allowed. Like, I was not allowed to do this. And I think that we're going to probably see more of this in the future, but because gender care is just becoming more accessible and wider spread, we haven't really seen the youth push back to break away from parental desire yet, but it's probably coming.
So this question is about SB 16 and some of the transgender laws. So sometimes required surgeries can be the same as gender affirming care, and I think you mentioned the gynecomastia issue. This questioner asked about an orchiectomy, which is often required for testicular torsion, but also might treat gender dysphoria. Is there guidance? Might a trans girl with torsion be in danger?
Would the trans girl be in danger? No. Would the physician providing the care be in danger of performing a legal procedure? Possibly. And that's where it's, a little confusing on our side. And that's why there's been so many healthcare providers who have stepped away because they can't figure out where all the lines are. And because there's gray zones, they don't want to put themselves in that gray zone. We approach it at the university that if I am doing a treatment that is for a diagnosis that is not related to your gender dysphoria diagnosis, I have due cause to be able to perform that procedure. So in the instance of testicular torsion, where you're at, the surgery for that, if you have a dead testicle that can cause other problems, I'm doing it for that reason. If I have a gender diverse patient who has severe symptomatic macromastia, neck pain, back pain, shoulder pain, and I am taking those breasts and I am making them smaller, I am not removing them completely, but I'm making them smaller. I am treating that symptom of symptomatic macromastia, which is different than treating the gender dysphoria. Could it help with the gender dysphoria? Sure. But that's not why I'm doing it. That's not my diagnosis code. That's not, even though the surgical code is the same, the diagnosis code is different.
And I think that just bolsters the argument that this is because of sex, right? Like the question, like these differences, that nuanced, discussion that we just had, like to me, it just points to really the only basis for this law is the sex of the transgender person. So
this question will be next just because it's related, but have these laws, including SB 16, driven providers out of the state? I mean, it's obviously great that you are staying in the state, Dr. Johns, but I'm sure it can be a hard decision if you're risking criminalization.
Yeah, I think that across the nation, it's done one of two things. I think that the people, and we had a lot of discussions within our group when all of the laws came down, and the desire to stay and fight for your patients and fight for their rights, in most instances is, stronger than the desire to flee. I'm sure some, physicians have left and gone to other states where, it's still legal. And then, but what I fear more is that providers stay in their states, but they just stop providing the care because they're worried about the legality.
With the Sixth Circuit case getting appealed to the Supreme Court, how optimistic are you about getting that Sixth Circuit decision overturned, given the current makeup of justices?
Well, I mean, there is a case called Bostock that is based on federal employment law that said that discrimination against somebody because of their transgender status is discrimination based on sex. And so, I can't really look in a crystal ball, but, and that was from 2020. That was a U.S. Supreme Court case from 2020. And so I'm not saying that that makes me generally optimistic. It's just a data point. But I think that, the fact that we're going to the Supreme Court, it just, shows that this is a fight that you sort of have to use every single tool in the toolkit from, going to the Supreme Court, going to state courts, fighting it in the legislature, community activism, everything across the board, because it is such an important fight and is going to require a lot of efforts and I guess potentially, the risk that there might be an adverse judgment, but we can't stop fighting.
I'm more pessimistic here, but I guess you all are doing the work and consulting, but my kind of dread is we're getting another Bowers versus Hardwick, right? And maybe, and relying on Bostock could be a problem. And so Bostock was a case under Title VII of the Civil Rights Act, and Gorsuch, writing for the majority, specifically didn't want to talk about gender identity at all. Right? He really protected trans rights, but not as trans rights and not under gender identity. So I'm pretty worried, but I understand the logic of trying to fight it and see. But then we could get a national ban, basically. I mean, that could be the consequence.
Can you help us understand the recent ruling requiring the release of private medical records, including mental health records of 2 trans athletes who are suing the state, and also discuss some of the potential repercussions?
Well, so that's talking about our lawsuit again, the lawsuit where we represent 3 transgender athletes who got that law struck down. And from our perspective, it is a case that involves sort of inherent dignity and inherent rights. And so, even as you're discussing the fact that singling out this group of kids for disfavored treatment would be very distressing, and you don't really need medical records to prove that, the state argued otherwise. And just based on the way that, courts are generally very reluctant to allow parties to hold evidence back or documents that could potentially be evidence back, because once you're in a lawsuit, the standard for being forced to hand over documents to the other side is kind of just relevance. And so the court disagreed with our very firm arguments that these documents are not relevant, they're protected. There's a very strong interest in protecting them. But the court said, I disagree, you need to provide them to the state. But the court actually did sort of take an affirmative step and say, you can redact extra sensitive, irrelevant information, and pointed out that, we can mark them attorney's eyes only or confidential, so that this is not the sort of information that could be shared publicly by the state attorneys. So, it's not a ruling that we are happy about, and we still disagree with the outcome, but that's what happened.
One question says, has any of you been threatened? But I want to make that broader and just ask, do you feel like there are personal risks to engaging in this kind of advocacy or research or medical care?
I mean, yes. Our team has received emails from the university that just state that, there are groups that have listed all of our names and our clinic locations and, have just put the general message that we are providers providing this type of care in platforms that are unfavorable for the care that we're performing. Our response to that is, great. So, what do you do about it? And there isn't a great answer for that, but it is a reality of what we do.
Yeah, I mean, we likewise get hate mail and hate messages, and I mean, ultimately, you kind of have to take it in stride. I mean, I've been at this for 11 years, and so it is something you just have to sort of compartmentalize, because to me, the work is too important.
So my great fortune is that they're not reading my work. So they're not on SSRN, so they're not threatening me. But it's not always pleasant walking around in certain spaces.
Okay, we have time for one lightning question, which kind of surged to the top with a few likes. What are the medical and PA NP students at the U being taught on this issue? Are they receiving any guidance from their professors and/or coursework? Lightning.
Yes. So medical students from medical level, they have courses, they've got, specific gender care tracks that they can be on, so they can make sure that they rotate through with us. From a plastic surgery standpoint, our residents get well trained in all facets of it because they're seeing our patients, they're seeing all the surgeries, and they're understanding the, paradigm of gender care. And then we have PAs that are dedicated to our gender team. So we have PA students that come and rotate with us. So there is quite a bit that's happening.
Well, I'd like to thank our fabulous panel for this discussion. And if y'all could hang out for a few more minutes in case people have questions. Are you going to conclude this? Yeah.
So I was asked to just say a couple of quick closing words. And I'm Leslie Francis, if you were here this morning. So I'd like to start the closing words by thanking everybody who's been involved in this. The IT staff, the events staff, all the folks who've worked so hard in the background to make this possible. Lee Teitelbaum, who I knew as a treasured colleague and wonderful human being, and his wife Herta, a longtime colleague here at the U. The law school generally, all of our panelists who have put, and some of them may continue to put, writing articles for what will be an enormously, I hope, I firmly believe, influential volume of our law review on not only how to think about changing the law, but also how to think about changing healthcare, as we heard in a panel right before, moving towards community models. And then, so my colleagues, Dan, Laura, Tennille, who I suspect was had to go for maternal responsibilities. And at the end, the law review. Thank you, everybody who was involved, especially Sarah, but every member of law review who is here or who has been working behind the scenes again on this, and the audience. So thanks a bunch, and keep up the good work, everybody.